President, please be seated. This afternoon, the Chamber will start to hear a witness 2TCW 808. However, before proceeding to hear this witness, the Chamber wishes to hear submissions orally by parties, particularly in relation to the request of the defense team for Nguyen Chia for the adjournment of hearings of witnesses in relation to S21 document E402. On Friday, 29 April 2016, the Chamber has sent an email through senior legal officer informing parties that the Chamber is intended to hear oral submission of parties on the two issues. One, should the Chamber adjourn this hearing, and how many days is proper for the adjournment? And number two, do parties have any objections to the admissibility of documents that can be used as the basis, that were used for the basis of the revised prisoner S21 list, the revised list of S21 prisoners, rather. The Chamber is now hearing the submissions and responses of parties so that the Chamber can have the basis for the deliberation and the decision on the issues. First, the floor is given to the co-prosecutors to register their oral arguments in relation to the request by the defense team for Nguyen Chia. You can take the floor now, co-prosecutor.
Thank you, Mr. President. Let me say that first, the co-prosecutors are opposed to the lengthy 4-week adjournment that is sought by the defense. Let me make a few observations on the basis of the request. The argument that the new OCIJ S21 prisoner list suddenly makes an adjournment necessary, we believe is not valid. The underlying records, the S21 prisoner records, which establish the numbers of prisoners and the identities of prisoners who were at S21 and who were executed, have been around a long time. They've been at DC Cam and Tool Slang for many years, many years. They've been on the case file almost since these investigations first began back 7 years ago, 8 years ago. If the defense felt it was necessary to do what they are talking about in this request, that is to go through and examine document by document every S21 prisoner record, they should have began this a long time ago. So we simply don't feel that there is any legitimate reason to have a 4-week adjournment in these proceedings. Certainly, the defense has a fundamental right, a fair trial right, to adequately prepare. These allegations relating to S21 are part of a closing order that was issued back 6 years ago. So the defense certainly has had adequate time to prepare on these issues. That said, So while we are very much opposed to a 4-week adjournment, noting that there is a public interest in these proceedings moving to completion. While the court needs to ensure, obviously, that the defense's rights are protected, it also has to have in mind the interests of civil parties and others who have been waiting many, many years for this case to come to completion. That said, we feel there's possibly a different avenue in which the court could give some more time to the defense to prepare for at least 2 of these witnesses, but at the same time keep the trial moving so that we don't lose valuable trial days and stay continuing to make use of the court days. What we have in mind is that we have 3 remaining S-21 witnesses that the defense has asked to be postponed. One of these, I should say there are 4, including the witness who will be heard next. But the 3 witnesses after that are the witnesses the defense would like to postpone. One of them, in our view, 2 TCW 906, is not a witness who is so much connected to the S-21 prisoner lists, which is the core basis of the defense saying we need more time. This is a witness who will primarily testify to general events that went on at Chengek and other sites, and not so much a person for whom specific prisoner records are pertinent. So we certainly believe that the court should continue and hear 2 CW 906 this week. The next 2 witnesses, 2 TCW 816 and 916, we do recognize that these are very complex witnesses who have not only a lot of past interviews, but do have a lot of relevant S-21 documents. So there is a way for this court to give the defense more time for these 2 witnesses, but keep the trial moving forward. And that would be to complete the next witness and 906, the following witness this week. And we would suggest, as an alternative to adjourning, that next week the court could call a few of the internal purge witnesses. There are a number of those witnesses which are very much connected to the S-21 section who are relatively easier witnesses to prepare for. Witnesses who have 1 interview, or in one case, 1 civil party application. And just so we have a clear record, the purge witnesses that we think it would be feasible, if, of course, subject to availability and the court's ability to bring them here. A civil party 2 TCCP 236 is someone whose, to my knowledge, only available statement is their civil party application. 2 TCW 917, 2 TCW 812, 2 TCW 976. These are all witnesses that have, to my knowledge, 1 or perhaps 2 statements. So one alternative that would allow the court to continue the trial moving forward, but give the defense time to prepare for these 2 more complex witnesses, would be to first hear some of the internal purge witnesses. We'd then have the planned week adjournment for the King's birthday. When we return from that, the court could either hear a few more purge witnesses or at that point return to these two complex S-21 witnesses. So we think that is a avenue by which the court can give the defense more time to prepare, but keep this trial moving along. I would note the defense has had a number of adjournments or breaks this year already. We just came off of April, where there was a week adjournment for Khmer New Year, and in February there was a lengthy adjournment while we had the Supreme Court hearings. While that was not a break for the Q Sempan team and the co-prosecutors, the Noon Che defense did not participate, so they had that time off. So they've had a number of breaks this year already, and we simply think a request for 4 weeks is unreasonable. Thank you, Your Honors.
I have one question for the prosecutor, actually two, but they are related. You're aware there is an alternative request by the Nunchia defense to basically let the co-prosecutors and the co-lead lawyer start and proceed with those three witnesses on the defense side at a later stage. Two questions in this context. First of all, your reaction to it. And secondly, should the chamber decide to do that, would the prosecution be ready to comply?
I don't think we view very favorably the idea of having three witnesses in a row who only are examined by the co-prosecutors, and then weeks later we come back for them to be cross-examined. I don't think that is the most efficient way to proceed. I would note in the case of the last of the witnesses, it's going to be a lengthy proceeding. We're going to have several days, so the defense is going to have substantial time to prepare while that is going on in any event. So it certainly would not be our view that it is a ideal way to proceed to split up with three witnesses in a row like that. In answer to your question, we're certainly ready to prepare for proceed with the next two witnesses. If that would involve the defense not examining and therefore the dates moving up, we'd have to step things. In other words, if you're saying that instead of us having 2 days with these witnesses, we'd only be spending 1 day, therefore they would be coming a lot quicker than we're expecting, if you understand me.
I do, but you don't answer my question in the end. Should we decide to do that? Would there be a preparation problem for the prosecution?
That's what I'm trying to say. Only if it meant, for example, that we were starting 2 TCW 916, for example, at the end of this week, because we're only doing 1-day examinations now. We certainly do need until next week to be ready for that individual, and there are obviously other considerations there. But we will move and do our best under whatever you decide. There's obviously always more time one can use with witnesses of this nature, but we will be ready to proceed as best we can, whatever. I realize I didn't answer one of your other questions too, which was, obviously we have no objection to the underlying records being admitted. And any party in our view that finds records that are cited in the OCIJ list which aren't admitted now, we have no objection to anyone putting those into evidence should they wish. I do want to make one remark. There's an indication here that it's problematic that the OCIJ list cites DC CAM numbers instead of other case file numbers. I'll note that in Xylab there is a field for the DC CAM document numbers, so you can search in Xylab by the DC CAM number. So that shouldn't be a problem in terms of searching for these records to the extent parties wish to follow up on individual prisoners.
President, and now the chamber gives the floor to the lead co-lawyers for civil party. You may proceed.
Merci, Monsieur le Président.
Thank you, Mr. President. I would like to make a few brief remarks. For a start, I would like to say what I say practically whenever such discussions come up, notably that the civil parties have a direct interest in ensuring that the trials move forward and close rapidly. But of course, the rights of the civil party to an expeditious trial cannot be ensured at the expense of the defense, and that is why we would rely on the discretion of the chamber as regards the establishment of the balance between the rights of all the parties to an expeditious trial and the rights of the defense, and that this should be ensured by the chamber satisfactorily. To respond to the questions raised by the chamber in its email dated the 29th of April, I would like to, first of all, respond to the second question because it appears to have an impact on the first question. As regards the second question, as regarding whether we have objections to the admissibility into evidence of documents that are the basis on which the list of the OCIG was drawn up, my response is that we do not object to the admission of those documents, but on the contrary, would wish that those documents be admitted. And if we understand the meaning of the chamber's email, it would be up to the chamber to identify those documents and to include them on the trial record at his own behest. That is how I understand the email. As regards new documents that could be admitted into evidence, we are of the view that the chamber should be able to answer the first question, that is, the question regarding the adjournment. On that point, once more, we will rely on the discretion of the chamber. Our interest, once more, is to ensure that the trial moves forward, but that it moves forward while respecting the rights of all the parties. As regards the proposals made by the non-Shia defense team in document E402, and in particular the proposals in paragraphs 32B and C, we do not see the interest in having a trial management meeting. We believe that the discussions we are having today would suffice to resolve that issue. We are also firmly opposed to the proposal made in paragraph 32C, and we urge the chamber to find a solution that would enable the chamber to respect the rights of all the parties so that we do not find ourselves in the situation in which we would have to split the testimonies of some witnesses and civil parties who will appear before the chamber. And we hope that the chamber will find a means of hearing the testimonies of witnesses in a continuous manner so that all the parties can put questions to the witnesses and civil parties one after the other. As for the proposal that has just been made orally by the co-prosecutor, that is to say that some of the witnesses who are called to testify on internal purges should be called before certain important witnesses who are due to testify on S21. We will endeavor to prepare ourselves accordingly if the chamber were to adopt that proposal, and we rely on the chamber to balance the rights of the parties in a fair manner.
President, thank you. And now the floor is given to the defense team for Mr. Kyu Sompon to register any arguments or observation, and also to respond to the questions put by the bench a while ago. You may proceed now.
Merci.
Thank you, Mr. President. I would like to start by saying that on behalf of the Kyrgyzstan team, I cannot say that we endorse the request for an adjournment of the proceedings made by the Nunchia team for obvious reasons. And I must say that the discussions we are having now are very revealing of the kinds of problems in terms of preparation that the defense may have in this segment, and in terms of the sequencing of witnesses. First of all, as regards the first point, we support the Nunchia defense team application, and we also support what he said regarding the admissibility of documents that served as a basis for the OCIJ's list of witnesses. And we would like the chamber to admit into evidence all documents that have helped in laying the foundation for the establishment of that list. These are very relevant issues for the chamber. I find it very revealing that the co-prosecutors, in answer to the question whether if they had to hear certain witnesses before others, and if they were to grant the defense application, explaining that they need time to prepare for themselves and that it is necessary to adjust the schedule of the chamber. I'm not saying so for the first time. When you look on the other side, that is the civil parties and the co-prosecutors, we have a number of co-prosecutors who work in rotation. We have the international co-prosecutor who is here present today. He was not here when the previous witness testified. And I suppose that in terms of preparation, that also means that the way the prosecution operates is different in terms of time management. And to say that for us to be able to resolve the times required by the defense to prepare themselves, the solution proposed by the co-prosecutors to have certain witnesses testify on the purges before others, that wouldn't help us at all. It would pose more problems, in fact, because we are stretched beyond limit, and we have an agenda that has been a schedule that has been proposed by the chamber, and we have envisaged using a number of days to prepare ourselves for those testimonies. And if we change the schedule, it would pose certain problems for us in terms of preparation. And in the face of such a situation, we are talking of equality of arms, and we have all admitted that is an equality in principle, so it is not real. In this particular context, and when we talk about an important segment, and when we talk of rescheduling the appearance of witnesses, it wouldn't solve any problem to us. So the impression you give is that the defense is asking for time and we are going to lose time. That is not the case. We are actually trying to gain time. The time we spend in courtroom is not the same as the time we spend in the court, in our offices preparing to take depositions. We prepare for examination of witnesses, and we are always present here in the courtroom, and we are not able to do anything else, which means that whenever we have a team preparing for future proceedings, we do not have the time to work on other things. This is something very important, and that is why we are of the view that if the court were to give the chamber the time, the defense the time they need, it would not be a loss of time. But what we are asking for is to be allowed to work when there are no hearings, and so that we can prepare ourselves concretely for the depositions of certain witnesses, contrary to the defense, the prosecution that has many members of their team. So bringing forward certain witnesses who were supposed to testify for a week or two, that wouldn't help us. In concrete terms, we do not have the means in terms of human resources and time. So we and our teams should be able to work in a reasonable manner. I'm not saying that it's normal, but just a reasonable, because no one can do what is impossible. That is what I would like to say in response to the first remarks by the co-prosecutors. I believe that if we really want to allow the defense to prepare themselves appropriately, particularly on this segment at hand regarding materials to be used, we don't have any choice other than to adjourn for a number of days. If the chamber were not to grant the Nunchia defense application, which we support, the only other solution that would be less likely to prejudice the rights of the defense in terms of preparations, since everyone says we should always be ready. So the only solution would be that the co-prosecutor should examine the witnesses first, and that we be allowed to use the next recess when the court will not be sitting, to try to catch up in terms of the time we need to prepare ourselves to ensure that the rights of defense are met. And so I want to say once more that, yes, in principle, there's equality of arms, but in concrete terms, given the fact that we, the defense counsel, are always in court, there are things that we cannot do, humanly speaking.
Just one question. Would you be willing to quantify the term several days? Because you talked about we might need some time, and you always said, or I think you twice said several days.
I thought that my answer was obvious in the sense that I said that I support the Nunchia application. In principle, we believe that 4 weeks should be enough to enable us to come up to speed in terms of our preparations.
President, thank you. And lastly, the floor is given to the defense team for Mr. Nunchia to respond or to reply to the responses of parties.
Yes, thank you, Mr. President. Let me start by first fully endorsing the words of Q Sampan's counsel, so I do not have to repeat them, but what Counsel for Q Sampan is saying is exactly applicable to our resources. And what the prosecution is saying shows that it really doesn't have any idea as to how incredibly difficult it is right now for the defense to keep up. I will get back to that, but let me first start by saying something in general, Mr. President. I think we need to put the request for 4 weeks a bit into perspective. Let me start by saying again, I've said that many times, the right to an expeditious or speedy trial is a right of the accused. Primarily, foremost, a right of the accused. If the accused thinks, and with him his lawyers, that he doesn't have enough time and that therefore the trial will prolong with, in this case, 4 weeks, then that is then that's so be it. It's his right. It is not something that you should balance with the civil parties. It is primarily and predominantly a fair trial right. Putting it in perspective, it's been now I believe 8 years and 7 months since Nguyen Chia was arrested and put in pretrial detention. Adding now at this stage a mere 4 weeks to proceedings that have been going on since it's the first criminal charge in September 2007 is of course completely reasonable and not at all out of perspective. 4 weeks, when you compare it with the total amount of time that we are now spending is certainly not unreasonable at all. Having said that, let me now address a few points that the prosecution has raised. I will not repeat the arguments that we have made in our motion E402. But let me say the following. Prosecution is saying, when it comes to the new list of the OCIJ, that a lot of underlying documents have been available to the defense since it first got hold of the case file. Of course, that is true. However, when the Office of the Co-Investigating Judges started doing this research, started doing this, making this complete new list, they apparently thought there was a good reason to do so. Just to mention one detail, it's not all detail, there's a discrepancy of about 2,000 or even 3,000 persons, 2,500 persons, former prisoners, between the list of the prosecution and the OCIJ. Who are these people that were not apparently noted in the list of the prosecution, and also for that matter in the judgment that the trial chamber issued against Duik? We don't really know which documents, at least not in detail, which documents the OCIJ have been using, how the selection process was. As you can see in paragraph 12 of our motion, the OCIJ reviewed anew 13,383 documents, and these documents include S21 prisoner entry logs, biographies, S21 staff logs, interrogation lists, execution logs. So they went through all those documents and then apparently relied, when making that OCIJ list, on 871 documents. Does the prosecution know which documents were already known to the chamber, to the other parties? I'm sure they don't. The reality is that we now have a list which, at least prima facie, seems to be more reliable than the list that was used by the parties in case 001 and the trial chamber. That new OCIJ list is a reality. We haven't asked for it, but you, Mr. President, the chamber at its own motion had that document, that list added, so now it is part of our case file, or soon to be. Just pretending that that OCIJ list is not there and just sort of assuming that we can just go quickly through it and then everything will be fine, that is really not the case. So, and of course, in paragraph 13 and 14, we also describe difficulties in analyzing that document, the ERN numbers that they're using, the DC cam. It's very difficult. But it is our task, our job as defense lawyers, to really make sure that we understand the methodology of that, that list, which documents were used. And to just give you one example, when we used that OCIJ list once with one of the witnesses who has testified here, we discovered in the document on which the OCIJ relied, and which is not on the case file but on the shared materials drive, that there were all kinds of interpretation issues. We believe that this OCIJ prisoner list is a fundamental new element to this trial, and the fact that it is overlapping to a certain extent is irrelevant when it comes to deciding whether we should have an appropriate time to review it. That is the first general point. The second general point Mr. President, is actually equally important, and it goes to what the prosecution said in relation to one witness, the witness 906, who isn't really related to the prisoner list, etc., and who has a different role. We really beg to differ with the prosecution in relation to that witness. And then we come to the second important point of our request. And that's something which I touched upon a bit with the last witness before the lunch break, but which is an overriding, a very important issue. In this very segment, the prosecution, and for that matter, most, or if not all, judges, except for the reserve judge, have all been involved in case 001. You've all prepared the examination of most witnesses years ago. The trial in case 001 lasted 77 days. You were all involved, except for the present civil party lawyers. You were all involved in those proceedings. It is correct, and what the Supreme Court has said, that we have to establish everything anew. But sometimes, Mr. President, I get the feeling that that is not something that is the reality of the court proceedings here today. Talking about 906, there are literally thousands of documents that we need to study and we need to read in order to be able to fully examine that witness. And the fact that that witness or his testimony was a long time on the case file is not really so relevant, because whatever a counsel has read 2 years ago, by the time that the witness is actually coming up, you've forgotten most part of it. And so that also applies to new members in our defense team. A lot of them weren't there 2 years ago, 3 years ago, 6 years ago, 7 years ago. So it's very important that the Chamber understands that everything that's coming in this particular segment is new to us, but it's not new to the Chamber, it's not new to prosecution. And that is what makes it fundamentally different from other segments. With other segments, Phnom Krol or the Trapiang Tma Dam, we had the feeling that we were all on the same level in terms of knowledge, in terms of preparation. But prosecution can just continue asking the questions that it wants to ask now, and it didn't have the time to ask in case 001. So it is not only this OCIJ list, which is indeed a new and very important element. It is also the fact that the upcoming 3 witnesses are so important, and the evidence involving them is so huge that a request to have a mere 4 weeks in order to be able to properly prepare is a very reasonable request in the light of the fact that we are already busy with this case for 8.5 years.
Thank you, Counsel. And Judge Laverne, you have the floor.
Thank you. Just a point of clarification, Counsel Koppe. I'm not sure that you answered the question. Do you have any objection if the Chamber declares admissible all of the documents that supports the new list from the OCIJ? Is there any objection in that regard?
Judge Laverne, yes, I forgot to mention that. We actually support the idea that all documents should be admitted to the case file. So our request is to have all underlying documents. Presumably, the number that I just mentioned, 871 documents. Not entirely sure what the other 12 12,500 documents are that the OCIJ investigated. But I think we should at least start with those 871 documents that it relied upon while drafting the OCIJ list. So yes, at least to the 871 underlying documents, possibly, but I cannot give you the answer now, also in relation to the remaining, 12,500 documents that the OCIJ list refers to.
Mr. President, we hear the issue of equality of arms all the time. If I can just say something briefly on that. First, I must take issue with the notion that the prosecution has a lot more resources. We added up the numbers earlier this year or late last year. There are now 4 defense teams in cases 3 and 4. When you add up the total size of the defense teams in cases 3 and 4 and the 2 defense teams here, when we last checked, they had more or the same number of lawyers and resources as the co-prosecutors. We don't just work in this case. The reason we rotate is a choice for the way we want to manage our resources, but all the lawyers have responsibilities in other cases, and contrary to what some people may hear, these other cases are extremely active right now. So put to bed this notion that we have some advantage over the defense, or that we don't understand how difficult this is. Believe me, we've been in trial now for 2 years. You probably see the bags under my eyes some days when I walk into this courtroom. It is extremely difficult, and no question about it. We simply think that the proposal of 4 weeks is far excessive. I don't think it's equal if the prosecution have to examine 3 difficult, complex witnesses by itself, back to back to back, and the defense then have 4 weeks off to prepare to cross-examine. That's not equality of arms. We obviously like to have as much time as we can too, and we have to work weekends and nights. The point I'm making is 4 weeks is excessive. There's a different way to do this that doesn't involve splitting witnesses and giving the defense 4 weeks to prepare. You're probably going to have to look at moving forward some of the purge witnesses anyway. If the last S21 witnesses, 916, can't testify consecutively 9 days in a row, we're looking in any event at either moving forward some of the purge witnesses, splitting up half days of that witness. So in response to the Q-Sampans team, I think we have to be ready for some of those purge witnesses, not all of them, and some of the easier ones to possibly be moved forward in any event. But mostly, I take issue with the notion that we have some advantage here. We don't. I didn't work on case 001. We're all equal in this courtroom.
I have just one question, because there appears to be a difference between the 2 defense teams. When it comes to the alternative request, which was, if you can't give us time to prepare, then let the other party start and with the witnesses, and we will do it when we are prepared. Counsel Giese said that doesn't help me because I'm sitting in the courtroom anyway, no matter who is questioning. Do I understand you correctly, Counsel Koppe, that you are saying that those are the witnesses for whom the list is most important? Is this the reason for the alternative request? Is it a possible option?
The alternative request is really an alternative and not so much something that we really want, because what Counsel Giese has observed is really applicable to us as well. The fact remains that if we were to pursue the alternative, I would be sitting here listening because I need to object to whatever the witness might be saying to certain questions, so I need to pay attention. So when I'm here, obviously I cannot do anything else. So it is really a distant alternative to what we ask primarily.
But you made the request, so how
We try to see what's usual at the other tribunals. The alternative that we suggested is something that you see often at the ICTY, at the ICTR, so that's why we presented this option as well.
Maybe a last observation regarding the issue of equality of arms. I didn't quite understand the co-prosecutor's argument regarding the teams assigned to cases 3 and 4, because contrary to the co-prosecutor's office, which cannot be divided, we in our teams, we do not have the possibility of working with the teams in cases 3 and 4. Nobody from the cases 3 and 4 come to help us and provide us with documents to help us prepare our examinations. And that's an important point. And when also told regarding preparation, I didn't say the prosecution doesn't work, but I note that when I'm working on a witness, sometimes I receive emails from other co-prosecutors who explain or that they're going to use such and such another document, which I suppose means that they're working on the future coming witnesses, whereas I'm in the courtroom working with other witnesses. So these are small elements that allow us to note that the equality of arms in terms of preparation for the witnesses of this trial is not exactly a fact. So I'd like the Chamber to take note of these extremely concrete elements. Maybe it's small potatoes here, but this is our daily reality.
The Chamber would like to thank all parties in relation to their responses and submissions, and the Chamber will use them as the basis for our decision so that it can be rendered in due course. It is now appropriate to have a short break. We'll take a break now and resume at 2:45. The court is now in recess.